We are continuing the conversation about title in real estate. With us, we have Lisa and Leslie with Lawyers Title. They're going to be sharing valuable information on how title works and how it comes up in common situations during a real estate transaction, and how title awareness is important in real estate.
Whether you or someone you know is curious about what title takes care of, this episode is for you. Make sure you share with family or friends so they can learn too.
I'm Isabel Machrone.
And I'm Rosa Ortiz.
We're real estate professionals in Southern California.
And each week we break down what sellers and buyers you need to know right now.
This is Let's Talk Socal Real Estate.
Hi, ladies. Welcome to our podcast, Let's Talk SoCal Real Estate.
Thank you for having us.
Thank you for being here. Today we have Lisa and Leslie with Lawyers Title.
Thank you.
Can you tell us a little bit about both of you ladies?
Sure. So I'm Lisa.Favorite with Lawyers Title. I've worked for Lawyers Title for over, 15 years and been in the title industry for 27. My job function is to call on real estate agents, lenders, escrows, and work with be the liaison between my inside staff and my real estate agents or clients.
I've known Lisa since our early 2000s, and she's amazing to work with.
How did you get started, Lisa?
Oh, that's a great question. So I graduated from Cal State Fullerton with a marketing and business degree, and my brother-in-law was in real estate. He owned a real estate office in the Corona area. He asked me if I wanted to come over and be his kind of PR marketing and work with some of the agents within his office, and I took that opportunity. So before doing title, which I started back in 1999 doing title, before doing that, I worked as a transaction coordinator for him and then started doing marketing and pretty much TC work and everything like that for about 4 years. That's
cool.
how I got in the business.
Hi, Leslie. Tell us a little bit about yourself and how long have you been part of Lawyers Title and how you got started?
I started in 1983. My family member was in title insurance. So I've been in the business about 43 years and 38 of those with Lawyers Title. I've done basically every position in the title insurance. I started as a typist and worked my way up through the search exam process. And I'm currently title operations manager for Lawyers Title Inland Empire. And I also handle all the advisory and claims for the office as well.
Beautiful. So what are the common mistakes homeowners make that cause or trigger tax reassessments?
I think some of the common mistakes that they make is having a deed recorded outside of a transaction when they go down to the county and maybe take title out of their name or go to put it in a trust, and it can trigger a reassessment if not all the proper documents are filled out, like a preliminary change of ownership form needs to be filled out correctly, and there's a few other things that go along with that. But a common mistake for triggering tax reassessment is when they are transferring title to and from.
Another thing to remember is any time you pull a permit on a piece of property, could be to convert a garage or to build a deck, or that can trigger a reassessment of the property as well.
What exactly is reassessment?
A reassessment is when the assessor deems this as an event for one of their appraisers to go out to the property and reevaluate the value of the property. So if you're paying $100,000 assessed value and you improve your property by $150,000 and that permit is pulled, that triggers them to send an assessor out to set a new value for the property.
Okay.
I'm glad you touched on that. I'm going to add one more thing to that, because oftentimes we are told that there's been permits done on a property, but they never finalize it. So we're Leslie saying that going out and taking a look at the property and doing that, when they don't do that, then that won't trigger a reassessment because it wasn't finalized.
Is that an issue for the property owner? I mean, obviously they'll see it as it's a lower value, then they don't have to pay a higher tax. But when you come to sell it, you do want that value on there.
When the assessor finds out in the sale that you did improve the property and it's a higher value, they will set out escape taxes at a certain point. So if you've done something to trigger a reassessment but haven't reported it, they will catch up and they will do that reassessment after the fact and hit you with an escape tax or a supplemental tax.
Resale purposes, it benefits the homeowner to get those permits, right? Because if they added to the property, added square footage, then they want to be able to count that as part of their home value.
Correct.
Absolutely. Absolutely.
So thank you for clarifying that,
And
ladies.
there can be consequences if you don't report it. The tax will catch up with you at some point, whether it's now, current, when you file the permit, or when you go to sell the property, it will catch up to you. They will reassess it based on that time frame.
Great point.
How long does a title insurance policy stay in effect after someone buys their home?
Until they sell the home.
So it stays the entire duration.
It stays the entire duration. Obviously, we do have homeowners that do refinancing. And when they do a refinance, the new policy comes into play.
Wow,
But they're
that's
still
great.
within the home.
We get a lot of questions about transferring title from themselves as individuals into their trust and whether they need anything, endorsement to their policy to add that additional insured. It's always a good rule of thumb to contact your title insurance company if you're going to do anything with the ownership on your property to make sure that it doesn't jeopardize the policy that's in place. An example of that would be somebody who has title, a homeowner's title policy, and they bought it as an individual. That transfer into an LLC or partnership would cancel out their coverage under the homeowner's policy because a homeowner's policy is designed for a natural person.
Wow.
If you transfer it out of that natural person status into an entity, it can cancel your policy or
Wow.
limit your
That's something I
policy
didn't know.
coverages.
Mhm.
So it'd be
We would
issued
have
to an entity.
endorse the file, correct.
So
Yep.
contact our title reps to add that person or that entity.
Right. If we will have to review the trust or the entity documents before we'll issue the endorsement
Okay.
to make sure that it is an entity that we can insure with that type of policy.
Very good. Good info.
Okay, great.
One of the things that we discussed with our escrow officer is all the changes going on with solar and how it affects title. There's a lot of solar companies that have gone out of business, and I know it's caused a lot of delays in transactions and trying to figure out who those liens belong to or what companies to contact. What have you experienced with issues with solar for homeowners?
I would just say if you have a client that has solar on their property, they should have the solar company information and the paperwork that goes along with that. So that would be helpful to know up front. We do have a marketing piece, which is really great that we put together at Lawyers Title that has some of the solar companies and the process that they require. We have a lot of the solar company contact information. So when the escrow officers are communicating with our title officers and on the inside staff, we're able to connect them with the right organization and usually help them along.
If you find that you have a solar company that's gone bankrupt or is currently in bankruptcy, we can look at the bankruptcy case and find out who the trustee is that's acting on behalf of that entity. Usually what we do is we contact that person and they can tell us where to order the demands from, where to get the contact information, who to call. So it's best to get your title company involved right away when you have solar. If you know you have a listing and it has solar and there might be an issue, it's best to reach out to your title agent and have them do some investigative work for you prior to.
Awesome.
Is there a situation where the homeowner doesn't know that their solar company went bankrupt?
It is possible. They continue to get an invoice. It's usually from Southern California Edison, and they'll get their credits on their bill. It is possible that they don't know their solar company went bankrupt, but they continue business through the bankruptcy process because the trustee is acting on the solar company's behalf.
Okay,
So
great.
it is possible that they would not know that until it comes down to closing and trying to contact that solar company for demands or releases or further information.
Okay. Can someone lose their home because of title fraud?
Oh boy. Okay, so I will take this one. Okay, title fraud is a really big issue right now.
Huge.
In title insurance. It is very, very common. The attempts are common not only on sale transactions, but also wire fraud, where somebody intercepts and tries to insert themselves into the deal and get the money out of the transaction. They are successful sometimes. Other times we're able to catch them and stop the transaction before it moves forward with the fraudulent party in place. But yes, there is one of the biggest common myths out there is I'm buying a property cash. I don't need title insurance. that's exactly when you need title insurance. You want to make sure that your title company is doing the research to make sure that you're dealing with the right party that has the authority to sell. You're dealing with the true seller, and not somebody who's inserted themselves into the business. We see this a lot with vacant land parcels where somebody inserts themselves as the seller. They contact a listing agent. The agent says, I can represent you. They contact the title company, and the title company does the research. Come to find out that we have somebody who's intercepted the deal. They've contacted the agent, and they're just hoping nobody asks any questions, closes the transaction, moves forward. When the real seller, the real owner out there has not entered into contract to sell their home. So you do need title insurance. There are so many preventative measures that we take to make sure that the seller is the rightful party to act.
Yeah.
That includes regular transactions, any kind of transaction. You want to make sure that you're dealing with the right seller.
We will look for that owner, and we will call them. We will ask them, are you selling this land?
Yeah.
And we've had them say, no, we absolutely are not involved in this transaction whatsoever.
Have you seen any with homeowners or single family homes?
There's fraudulent deed transfers between family members. That's something else to consider. You might be dealing with the family of a decedent, or you might be dealing with the brother or sister. We see fraudulent conveyances between family members all the time. Single family residences, commercial transactions, vacant land parcels. It's not just the fraudster, it's family members that do this to each other as well. So it is something that we definitely need to watch for on every single transaction.
And
also,
who catches?
If you don't mind me adding, we also talk with, I know Leslie does more than us as sales executives, but with the other title companies as well. So if we see something going on a file or a transaction that is fraudulent, we will flag that file and alert pretty much everybody that is involved with us through the F&F family, just to make sure that doesn't happen and go through on another transaction.
Who gets alerted besides the homeowner? How do they get prosecuted if these people get caught?
Yeah. If there's fraud suspected, we alert the agents, and the agents advise their clients. If it's a valid client that you're dealing with, that there is a fraudulent attempt on the property and they need to contact the district attorney's office, real estate fraud division. That's the first step, is to contact law enforcement. As a title company, we don't get involved with the actual reporting of it unless the attempt was made through us, like through attempted wire fraud. We're not going to try to catch the fraudster. It's very important to us to keep our employees safe. So we recommend that the agents report this to the district attorney's office, and they'll take it from there.
Okay, good to know.
If a parent passed away and you're on that deed, does it get reassessed?
No, typically if there's no consideration for the conveyance, it's not going to get reassessed. Traditionally, the assessor's office will look at any transaction that has a transfer of money involved with it as a potential for reassessment. That doesn't mean they won't reassess it. An example of that would be if a homeowner or a mom or a dad owned the property and had certain exemptions on their taxes, and it wasn't reported at the time of death. 10 years down the road, if it's reported in the close of a transaction, their assessor's going to go back and reassess for those prior 10 years for the exemptions that where the benefiting actual person has been deceased.
Yeah, whatever county that the property is located in, if it's, let's say, Orange County, Riverside County, you have 150 days to notify the assessor of that person's passing.
Okay.
It doesn't mean that obviously they can't deed off of the property. And if if the sibling is not getting ready to sell the property, then really, other than notifying the county of the passing, that's really all that they need to do.
Okay.
Now, down the line, if they decided to sell the property, we would establish their death by them providing us a certified copy of the death certificate and some other paperwork. That's when they get ready to go to sell. So sometimes I get that question, hey, Lisa, we just had a family member pass away. We need to take them off title. And I'm like, you can't. That doesn't, they can't sign off, unfortunately. So it really is a non-issue until they get ready to sell the property.
An affidavit of death
True.
and a death certificate now to establish the death of records. They don't have to do it later.
Yeah.
But And that will also alert the assessor's office. I think the big key indicator here is if there was any exemptions that the decedent was getting on their taxes, it stops when they pass. So you want to alert the assessor so that you don't 10 years from now get hit with escape taxes from the prior 10 years where you didn't notify them of the death.
Wow, so that's important to
Correct.
stop any exemptions being received by the parent.
Because it will catch
Right.
up.
Anytime anyone is on title to a piece of property, you should record an affidavit of death. That sets the notification process to the assessor.
Okay.
So husband and wife as joint tenants, if one of them passes away, you would typically record an affidavit of death for that party, and it leaves the survivor of the two in title.
That's great to know.
What happens if a homeowner passes away without a trust and they're the only ones on
Well,
title?
if they're the only ones that are on title and they pass away, that means probate. Some form of probate. There's different forms of probate in different estate values. So it would depend on the value of the estate of the decedent as to which process they go with. But if you're on title alone, it typically means a probate situation. So it's best always to have a trust or some other form of ownership that deals with the property after your death, so that
Super
you don't
important.
have to go to probate.
I was hoping you would touch on that because that's we see that often, and it's not nice news to give, not only to you as real estate agents, but for you to have to tell your clients. I think the most important thing to know is if it's a probate situation, often we hear that they did a refinance, it was in a trust, and then they took it out of the trust to do a refinance and did not record the
it.
deed back into the trust. We see that happen so many times, and it's not the best news to give to anyone.
Right.
There is a different process for that. It's called a Hegstead. It's just a different way to go through the court system, and it might be a little bit faster because probates can take a long time depending on assets and siblings and
The value of the estate.
and everything like that. So if the intent was to put it back in the trust and they didn't, we have a little bit of a different scenario, but still it would have to go through the court.
And it puts you in a position of having to petition the courts for a court order putting title back into the trust.
Very good information. When you get deeded off of a parent who had exemptions, that is also pertains to like if somebody had Proposition 19. Is that
Sure.
Right.
one of the
Yeah.
exceptions that they have to come off of if now the parent passed?
That is correct.
I think the best advice to give anybody about any type of tax exemptions on property, whether it's Prop 19, is to, first of all, what's great about Lawyer Style is we have some sources for clients to do that, right? They can get in as a consumer and they could say, go through a Prop 19 calculator. Our county assessor's office has a great website with not only their calculator that's on there, but the BOE forms from the Board of Equalization where they could file for the claim or get all the information from that. It has all the Prop 19 different scenarios that go along with it. So I think the best advice is, just to make sure you direct those questions to the county assessor because all that information is on there. It could be for Prop 19, having that lower tax base and being able to transfer, you have to be over the age of 55. There's so many different little variables that go along with it. And then there's the parent to grandparent transfer and
It can be complicated.
or to child transfer. And there's just other scenarios.
Can you give us just a brief summary of what Proposition 19 is?
Prop 19 is where you transfer your lower tax base, but you have to be over the age of 55. It has, and there's also a few other factors with being disabled or a wildfire. So those, if you fall under those factors, there's different scenarios as far as what form you would fill out through the county assessor and what type of tax benefit that you would be able to get from going from taking that tax base from your current property to your replacement property. And one of the key things to know is it does have to be your primary. So I had somebody ask me last time if I could take my rental property that I have in Corona and do that, sell that property to receive that tax benefit and go through Prop 19. And the answer is no, it has to be a primary residence.
And does it have to be within the same county or can it transfer from county to county?
It can go from any county. It cannot go out of state. Okay, that's a big no-no. And there's some other caveats that go along with that, but for the best part is, and you can transfer it up to 3 times. It used to be you could only do it once. And it used to be you had to find a replacement property that was equal or lesser value. And now that's not the case anymore. It can be of higher value. So there's a lot of good that goes along with Prop 19, and there is tax savings there. That's why the calculators with our title company or with the county assessor is very important. But there are some other stipulations when it comes to the, grandparent and child transfers and things like that, that you would just need to look at.
There's a lot of detail to it. And I do the same thing. I refer my clients to the county assessor's website because they have all the information and they can even call and ask directly.
Yeah, I would just say this again, redirect them back, because there are some tax consequences. You'll see families that have to sell because the value is so significant between the transfer. Back when this used to be 60, 90, and 110 was the proposition for that. And all I'm going to say, again, I'm not an expert on all the propositions, but I know enough to know that when that used to be in play, it kept it at such a low tax base that all these families that had properties back in the 70s and 80s that were transferring, in a trust, or had them in a trust, and that their children were getting them, they were benefiting from that tax value. And then in 2021, they said no more, right? They said, we're not doing that anymore. They updated to Prop 19, and that took that away. So the tax hit can be significant depending on the value of the property that the child can get from the property that's been in a trust.
Right.
It's the craziest title issue you've seen in the past.
Over the years, we've had a lot of crazy deals. And I guess on this particular transaction, we had it was a land scenario where the agent was contacted by the supposedly seller that wanted to sell their land in Murrieta, and the seller lived in LA. The real estate agent had not met the seller of the property, even though they were in LA, and everything was done verbally over the phone. Never had a meeting in person. So by the time we found out everything that was going on, it was an escrow. There was a buyer agent involved. And the statement of information, which we should touch on, it's a very important form in our real estate business, especially in our title business. It's a one-page form that is basically saying who you are, your driver's license, your social security, and where you've lived in the last 10 years.
Where you've worked in the last 10 years.
What we're looking for is to make sure that when we're going through the process and doing our title examining and everything like that, that there's not anything else that's going to be attaching to the property. And that statement of information helped us tremendously, because we told the real estate agent, you need to get that SI over to us because something's not adding up here. There was more going on with it, but when we got the SI back, the statement of information, when we got that back, the name didn't match what the driver's license.
Well, I'm gonna go back a little bit because remember the agent thought this was going to be a quick sell. He had a client that wanted to sell the property quickly. He needed the money for something. The agent looked at the property and said, it needs to be mowed a little bit. It needs to just be cleaned up. So I'm going to invest money into this deal of my own.
$6,000 in of his own money.
Yeah, so that he cleaned up the property for a quick sale. So when we got that statement of information back, we started to notice some discrepancies because, again, lawyer's title in the background does some investigative work just to make sure that we're dealing with the parties that they say they are. So we started doing investigative work, and the bottom line is all these little pieces started coming together. Come to find out, we were working with a fraudulent seller. We contacted the notary on the deed that was provided to us. The notary said, I did not notarize that document. This is the second time in a month that somebody from Southern California has contacted me and asked me about my notary. She said, I did not notarize that document. So now we had a third piece of evidence showing that we had a fraudulent transaction. We notified the agents involved, and you can take it from there.
He was disbelieving of it. He didn't believe it was true. But come to find out, they felt the escrow was involved. There was a little bit more. I mean, we talk about crazy scenarios. The escrow wasn't involved. The escrow was getting bamboozled too. It was just a lot of different moving parts. So we said we were no longer going to go forward with the transaction. And the agent wasn't very happy with that, but understood why. He was more upset about the fact of losing the upfront money for cleaning up the property. And then he did report that to the DA.
Yeah. That he was willing to risk putting that much money up front, not doing the investigation.
That's what we thought. Mm-hmm. Yeah.
said, I invested $6,000 of my own money up front for this. And anyway, it was a lot for that one.
One little step that we were talking about earlier, you work very closely with escrow, and we get to the end of the transaction. The loan gets funded, and right before recording, can you tell us what that means?
Sure. So I just had that. We're at month end right now. I had one of my agents say, hey, we just funded and it's getting ready to close. I love this. You need to record it early.
Yeah.
So the first thing, and I hear that from my agent. So of course, the first thing I do is I check with my title officer, who is obviously communicating with escrow. First thing I ask is this set up? And the second thing I ask is, do we have everything we need on our end? Do we have the wire? Has the wire hit, for us and when we're waiting for the wire? And this particular transaction, it funded. We had the wire. We release it. When we say we release it for recording, that means we are releasing it with the county. In this particular case, it was the county of Riverside. So the county, it goes in a queue, and you may want to touch on that. And that's a great question, because it goes in a queue, and I say, okay, well, how many is it ahead of it? Because, it is month end, and so a lot of properties are recording with the county, so we can see what place it is in line for that. And when I say recording, it's the grant deed that they're getting ready to do. Yeah.
Right. So when the documents are scanned into the file, they're electronically transferred to the county recorder's office. They are transferred into a queue by the number, and it's in the order in which they were received. So when Lisa says, what number in the queue is it? We can actually go in there and see all the documents ahead of it for
That's
recording,
pretty cool.
and tell you exactly when you can anticipate that you might get confirmation.
So on this file, they said, the agent said, it's very important. It's a contingent sale. The money needs to get to the second leg. Is there any way you can get everything going smoothly?
Expedite it.
That's where it's great. Yeah, it's great to know when you guys tell us that, especially your clients will appreciate it as well, because then we can behind the scenes get with our payoff to get what we call pre-figures over to your escrow. It just makes it all a smoother process. Communication is everything. You want your clients to be honest with you, and we want to be honest with you guys as our real estate agents too, and let you know exactly what's going on. So to have that communication where you say, hey, this is what's happening. If you give us just that little heads up, then we know. We're at the county's mercy as well when it comes to recording of the document. So we just can't all of a sudden, well, we do pull some behind the scenes stuff, we do some behind the scenes stuff.
You
We
do a
probably
lot, yeah.
shouldn't say we can't, but yes, there are things on the title side to make things happen, to make it go smooth. And it's behind the scenes often.
Yeah, because
Right,
the
and
realtor
from the
cannot
actual-
assume that you guys know the whole scenario of that client. Like, for example, what you were saying, that they were waiting for you can you expedite this recording? Well, you probably didn't even know that they were waiting to fund their next home, right? Or you did know?
If we're not handling the escrow, we might not know that there's a second leg, because every deal stands on their own, right? So unless the escrow notifies us, hey, we need a quick setup, quick submission, and confirmation as soon as possible, we don't even know that there's a second leg.
So that the escrow or us.
Exactly. Typically, escrow and the lender will send us the documents ahead of time. We get notification that the lender funded and to watch for the wire. We document our file what the wire amount is so that we can watch our bank account for that wire to come in. Once the wires come in, it's assigned to the file and payoff is notified. And at the same time we notify payoff that the money's in, we hit the button at the county recorder to release the documents, because everything's done electronically.
Okay.
So we scan the documents into the county recorder ahead of time. And when we get the wire, all we have to do is hit submit. So then we're actually in the queue in order for recording.
Okay.
Once the county recorder gets the documents, they review them and they record them. We get an automatic notification. Documents are deposited back into our file with a recording stamp on it. And this is the step that everybody forgets. There is a step in between confirmation and final payoff. We have to reconcile the
That's
title
the
file
little part I was
to
talking
make
about.
sure. Yeah, we have to reconcile to make sure that we've gotten all the fees entered into our file correctly before we can actually hit confirmed and it's sent over to escrow and the lender or agents, whoever's on the file. Click that button and you get your confirmation. Payoff department gets their confirmation to proceed with the disbursement of the file.
And that usually happens within 1 day or 24 hours after funding.
Yeah, usually within an hour.
Well, within an hour of recording, but not of the lender funding the loan.
Correct. An hour of confirmation of recording.
Yeah, of recording. Okay.
How can people protect their title? I know there's third-party services, but they can bypass those third-party services. What can people do to protect their title and get notifications?
One of the nice things that lawyers' titles is when we close a transaction and we issue an owner's policy to a buyer, they're automatically entered into title reporting with F&F called Monitor in Here. So if you have a title policy from Lawyer's Title where you are the insured, you're automatically going to be entered into this, and you will get a notification if anybody enters your property into the MLS. You'll get a notification if anybody tries to record a document against your property. It's automatic. It's a free service. And it is in place for as long as you own the property.
That's amazing.
Yeah, great.
It's provided free of charge to the insureds if they close a transaction with Lawyer's Title.
Also, if they're not with lawyers and they don't have that notification program, so do they go to the county then and sign up for something?
The county will notify the homeowner if there has been any type of transfer that has been going on, but sometimes it's too late because the transfer's been done.
Right. So, and all of the counties in Southern California have an automatic fraud assistance program where if something is recorded on your property, a notification is sent to you by mail alerting you that the document has recorded on the property. LA County, you can enter into their system and they will send you notifications by email. Or there's Home Title Lock as a service we get a lot of questions on Home Title Lock, and it is a service that's provided to clients. They have to enter into a contract for that and they pay monthly for that service.
Mm-hmm.
Yeah, but if you're providing service or if you can log on to the county clerk's office.
Yeah, the county has that. I think San Bernardino has it as well.
The only one that's online is Los Angeles County. All the others automatically send a notification by mail to the homeowner at their registered mailing address.
Yeah, but that's after the fact that it's been recorded.
Yep.
And we're trying to figure out a way to prevent before recording, which right now.
Well, that's Lawyer's Titles Monitor in Here.
Yeah.
Because if somebody enters something into the MLS system on your property, you automatically get a notification. So that's preemptive.
That's awesome.
That's advance notice for sure. Excellent.
Yep.
I don't know if you have anything that is important that we didn't talk about.
I have something in the payoff process, if we can go back to the payoff process. Something important to remember is, we talk about we're leg one, and sometimes the parties have a leg two to their transaction where they're selling their property and they immediately want to close on their purchase property. One thing to remember in that process is if the sellers have a home equity line of credit on their property, they need to freeze and close that line before we close, because if they have a line of credit and
Great tip.
So it's a nice reminder to tell your clients, if you have a home equity line of credit, go ahead and freeze that account now so that we don't have any delays at the end of the transaction.
That is great advice because it does happen. And even though I may put that in my prelim reviews and everybody's aware of it, it does sometimes not happen until the very end, and then they get upset.
That's a great tip.
Yes. Thank you so much for that.
Perfect. Thank you so much.
Yes. Thank you for being here with us and educating us and our listeners.
Thank you.
Ladies, have a
Thanks for listening. Let's talk Socal real estate. If this episode helped you, be sure to subscribe, follow, and share. And tune in for new episodes wherever you listen to podcasts. If you're thinking of buying or selling in Southern California, click the link in the show notes for your free buyer's guide. If you have any questions, email us. We'd love to answer them all.
Isabel Machrone and Rosa Ortiz are licensed real estate agents with Keller Williams College Park. Each Keller Williams office is independently owned and operated.
The information shared in this podcast is for informational and entertainment purposes only and reflects our personal opinions and experiences. It should not be considered legal or financial advice.
We make no guarantees regarding accuracy, timelines, or results. We always recommend consulting with licensed professionals and doing your own research before making any real estate decisions.